and thank everyone for joining us today for our webinar, U.S. versus Philip Morris, the big win against big tobacco. Here's the agenda for today. My name is Desmond Jensen. I'm a staff attorney here at the Tobacco Control Legal Consortium at the Public Health Law Center. And I'll start us out with an introduction to the case, and then we're going to have Denny Hannigan from the Campaign for Tobacco-Free Kids. Dennis Hannigan is the Director of Legal and Policy Analysis at the Campaign for Tobacco-Free Kids. He focuses on issues involving FDA regulation of the tobacco industry, as well as providing legal guidance on federal, state, and local tobacco control legislation. Prior to joining the campaign in September 2012, he worked for over 2 decades at the Brady Center to Prevent Gun Violence, first as Director of the Center's Legal Action Project, and then as the Center's Vice President. Before his tenure at the Brady Center, Denny was a partner in the law firm of Foley and Lardner. Denny will discuss the public health intervention and some of the remedies litigation. Next, we have Mark Gottlieb from the Public Health Advocacy Institute. Mark Gottlieb is the Executive Director of the Public Health Advocacy Institute at Northeastern University School of Law in Boston. The Institute's 9 attorneys conduct legal research and policy analysis around the intersection of law and public health. In addition, the Institute operates as a nonprofit law firm litigating public health and tobacco cases. For the past 20 years, Mark's work has focused his research on legal approaches to reduce the harm caused by tobacco industry products. He also teaches the Public Health Legal Advocacy Clinic at Northeastern University School of Law. Mark will discuss the impact that this case has had on civil litigation. Finally, we have Cynthia Hallett from the Americans for Non-Smokers' Rights. Cynthia Hallett is the President and CEO of the Americans for Non-Smokers' Rights and the ANR Foundation. Over the last 27 years, she has spearheaded successful smoke-free air campaigns that increased population protection from secondhand smoke, tracked and exposed tobacco industry interference in public health, published journal articles on health disparities of smoke exposure, presented as the keynote speaker at multiple national and international conferences, and served as the media spokesperson for the Smoke-Free Air Coalitions. Cynthia will discuss the impact of the case on tobacco control advocacy. And then we'll finish up with questions from you. All right, let's get started. While great strides were made in tobacco control starting in the 1950s, there's a confluence of events that happened in the 1990s that significantly accelerated the tobacco control movement. In order to fully understand the importance of the U.S. versus Philip Morris, it's important to put the case into the proper historical context. Because of time constraints, I have to gloss over decades worth of important events, and unfortunately there's no way to acknowledge all the thousands of people who worked tirelessly over the years to fight big tobacco. But in order to set the stage, we jump to 1994. That year, the FDA publicly announced its intention to regulate cigarettes and smokeless tobacco. Several news agencies published extensive exposés on the tobacco industry, including reports on the industry's manipulation of nicotine levels, which led to a defamation lawsuit by cigarette manufacturers. Tobacco industry whistleblowers came forward with millions of pages of documents and personal accounts of the industry's business practices. A series of hearings were conducted by the House Subcommittee on Health and the Environment, led by Chairman Henry Waxman. You may recall 7 tobacco company CEOs infamously testifying that they believed that nicotine wasn't addictive. The Department of Labor proposed a rule to eliminate smoking in all U.S. workplaces, which unfortunately never became a final rule. And finally, the event I want to highlight for our purposes today, the states of Mississippi, Minnesota, and West Virginia filed lawsuits against cigarette manufacturers seeking compensation for the payments the states made to the Medicare and Medicaid systems to treat tobacco-caused illness. Those were the first states, but they were not the last, as eventually 42 states filed lawsuits against cigarette manufacturers. 4 states, Florida, Minnesota, Mississippi, and Texas, settled their cases with cigarette manufacturers, forcing the industry to discontinue certain business practices and to pay the states compensation. The other 46 states, the District of Columbia, and several U.S. territories collectively settled with cigarette companies in a settlement known as the Master Settlement Agreement, which I'm sure many of you have heard of. Similar to the individual state settlements, it puts an end to certain business practices, like the use of outdoor billboards and cartoon characters, and forces the tobacco industry to pay compensation to the states in perpetuity, which is a fancy lawyer way of saying forever. Until the end of time or the end of cigarettes, the tobacco companies will pay the states. At this point, the companies have paid out over $100 billion to the states. That's billion with a B. If you're interested in the MSA has peaked, we have more information on our website, including an extensive webinar that's archived. I'll also just flag now that we have lots of resources about the U.S. versus Philip Morris as well, including an interview that we just did with Sharon Eubanks, who represented the United States in this case. It's a really interesting conversation, so if you want to dig in deeper after this webinar, please visit our website. Now, why highlight the MSA before we discuss U.S. versus Philip Morris? Well, essentially, it's the immediate precursor to the filing of this lawsuit. The MSA was executed in 1998, and this case was filed in 1999. And just like the state cases against cigarette manufacturers, this case began its life as a Medicare compensation case. Here are the causes of action that the government named when the case was filed in 1999. These causes of action are the legal theories as to why the government believed that the tobacco industry owed it compensation. As you can see, 2 of the government's 4 claims are related to the recovery of medical costs. I won't go into an in-depth explanation of these claims because the Medicare system is very complicated and they're largely irrelevant because the court ultimately dismissed these 2 claims. However, the government won on its other 2 claims. Both of these are related to the Racketeer Influenced and Corrupt Organizations Act, or Rico. We'll circle back to that in a minute. The plaintiff in this case was the United States, and here we have the original list of the defendants. These were all of the organizations involved in the industry's conspiracy over the years. Due to mergers, acquisitions, and dismissals, this is the list of defendants today. Essentially, Altria and Reynolds are the only remaining defendants who are still litigating the case and have the remedies imposed on them. The other defendants are now part of those companies, they were dismissed from the suit, or they simply don't exist anymore. Now we'll run through the timeline. The case was filed on September 22nd, 1999, while Janet Reno was the Attorney General under then-President Bill Clinton. From that time until September 21st, 2004, almost 5 years to the day, the parties filed motion after motion with the tobacco industry trying to whittle down or dismiss the case. On that day, opening arguments were finally heard. So the case was filed with the Clinton administration still having a full year left in office, and oral arguments didn't begin until just before George W. Bush was up for re-election. 9 months later, on June 7th, 2005, closing arguments were heard. If you're a lawyer, you need no context for how long that is, but if you're not a lawyer, I can tell you that 9 months is an incredibly long time for a trial. On July 7th, 2005, several public health groups intervened to become parties to the litigation. Denny is going to talk about this, so I won't give away any spoilers here. Finally, on August 17th, 2006, 10 years ago, Judge Kessler issued her ruling, finding that the tobacco industry had violated Rico and imposed several remedies on the industry. Of course, the tobacco industry appealed this decision, and on May 22nd, 2009, the Court of Appeals upheld the findings and ordered some slight modifications to the remedies. Denny will be discussing the remedies litigation as well, so I won't go into great detail here. I'll also flag, just so that we're thinking about the breadth of this case, that the Court of Appeals decision came down a few months after President Obama took office. On June 28, 2010, the U.S. Supreme Court declined to hear the tobacco industry's appeal, which made the Court of Appeals decision final. That was the day before the retirement of Justice John Paul Stevens. That was not the end of the case, however, as the industry began attempting to erode the scope of the remedies since the decision was final. Also, on April 4th, 2011, the industry filed a motion asking that the court's opinion be vacated because of the passage of the 2009 Family Smoking Prevention and Tobacco Control Act, which is the federal law that gives the FDA the authority to regulate tobacco products. The industry argued that this new law would prevent the defendants from committing future violations of Rico. On June 1st, 2011, Judge Kessler ruled that the decision should not be vacated, and on July 27th, 2012, the Court of Appeals upheld that decision. So that was a really fast run-through, but I just wanted everyone to have a sense of the scope of this case. It has been ongoing through 3 different presidential administrations at this point, and it will not be wrapped up before January 20th next year, so it will stretch into a 4th administration as well. So next I want to highlight the 2006 opinion, and let's talk about the scope of that ruling first. This is a huge opinion, and this is true in every sense of the word. Judge Kessler outlined the tobacco industry's business activities that violated Rico from the 1950s to the present, and the opinion relies heavily on millions of pages of internal tobacco industry documents. Before we talk about the actual decision, it's worth mentioning how long the decision is. For context, most of the important lawsuits in our history that everyone knows the name of typically involve some complex legal issues. Now, oftentimes this means that it takes a judge a while to explain the reasoning behind the decision. So here are a few cases that everyone on the webinar is likely to have heard of, if not by name, then by reputation, and the number of pages that the lower court opinion spans in the official report. So Roe v. Wade, the major abortion case, 8 pages. Brown v. Board of Education, desegregating schools, 21 pages. Bush v. Gore, the case deciding the Florida ballot issue in the 2000 election, 30 pages. You might not actually know the name of this one, but it's one of the cases challenging the Affordable Care Act, the National Federation of Independent Businesses v. Sebelius, 51 pages. Now, Judge Kessler's 2006 lower court opinion in U.S. versus Philip Morris with the reporter pagination is 987 pages. The slip opinion version, which I use for reference, is well over 1,600 pages long. There's a picture of the 2 binders that it takes up on my bookshelf. This is how much paper that it takes to fully document the tobacco industry's business practices that violate Rico. So let's actually spend a couple minutes talking about Rico. Outside of the tobacco control context, if you hear anyone discussing Rico, it will almost certainly be related to organized crime. The act was passed in 1970, and the original purpose was to give the federal government a new tool to combat the mafia and other forms of organized crime. Here again are the government's causes of action. As I discussed, the medical reimbursement claims were thrown out, but the government won both of its Rico claims. Now you'll notice probably now that there are 2. It takes a minute to explain how Rico works, but I think it's worth discussing. Rico is essentially about racketeering activity that furthers an enterprise. The enterprise is an association of people, companies, and or groups. It does not have to be a legal entity, so you don't need to incorporate your enterprise, which makes sense because it's unlikely that anyone participating in organized crime goes to their Secretary of State's office to file paperwork to declare their associations. Racketeering activity is the commission of specific acts that violate a host of federal laws. These violations are referred to as predicate racketeering acts, because in order for a court to find that you violated Rico, the court must first find that you violated one of these other acts. The list of predicate racketeering acts in Rico is very long, so I won't list them all, but I will highlight a handful just so that you get an idea. The act lists several violent crimes, like murder, kidnapping, arson, and robbery, as well as other crimes like gambling, extortion, and trafficking in drugs. Rico also includes a laundry list of federal law violations like wire fraud, mail fraud, financial institution fraud, counterfeiting money, counterfeiting passports and citizenship papers, witness tampering, etc. And some of the most serious offenses relate to human trafficking and the making or selling of chemical, biological, and nuclear weapons. So violating Rico puts you in the company of some of the very worst criminals. Now, let's put the 2 pieces together, because committing wire fraud or selling biological weapons doesn't necessarily mean that you violated Rico. We're dealing with 2 types of Rico violations from the government's causes of action. First is 1962C. Under this provision, it is a violation of Rico for any person who is associated with an enterprise to conduct the enterprise's affairs through a pattern of racketeering activity. A pattern of racketeering activity is the commission of 2 or more of the predicate racketeering acts that we just discussed within 10 years of one another. Judge Kessler found that the predicate racketeering acts in this case were related to wire fraud and mail fraud, and the decision makes clear that all of the defendant tobacco companies committed at least 2 predicate racketeering acts within 10 years of each other. Okay, I'm not supposed to read text off of a slide, but Judge Kessler can't really be paraphrased. So, as to the violation of 1962C, she ruled that defendants devised a scheme to defraud and used mailings and wire transmissions for the purpose of furthering it. The purpose of the scheme was to obtain from smokers and potential smokers money, that is the cost of cigarettes, to fill the coffers of the corporate defendants. Put more colloquially and less legalistically, over the course of more than 50 years, defendants lied, misrepresented, and deceived the American public, including smokers and the young people they avidly sought as replacement smokers, about the devastating health effects of smoking and environmental tobacco smoke. They suppressed research, they destroyed documents, they manipulated the use of nicotine so as to increase and perpetuate addiction, they distorted the truth about low tar and light cigarettes so as to discourage smokers from quitting, and they abused the legal system in order to achieve their goal, to make money with little, if any, regard for individual illness and suffering, soaring healthcare costs, or the integrity of the legal system. If I had more time, I would say let's take a minute to let that sink in, but unfortunately time today is short. The second violation of Rico is 1962D, which establishes that it is actually a separate violation of Rico for any person to conspire to violate the other portions of Rico. That is 1962A, B, or C. In this case, the court found that the tobacco companies had conspired to violate 1962C, which is what we just discussed. In the law, conspiracy is when two or more people come together to agree to do something, usually something illegal. Under Rico, the government must prove that the defendants knowingly agreed to the commission of two or more of the predicate racketeering acts. So under this portion of Rico, Judge Kessler found that the defendant tobacco companies did in fact come together and agree to further their enterprise through a pattern of racketeering activity. The court notes that the conspiracy began in December 1953 when the cigarette companies first came together to create the Council for Tobacco Research. The court found that the cigarette company defendants jointly participated at various times and to various degrees in creating, funding, directing, and controlling the defendants, Council for Tobacco Research, the Tobacco Institute, and other entities, and causing those entities to commit numerous racketeering acts to further those shared objectives. Furthermore, the frequent oral and written communications between and among defendants illustrate their joint efforts to pursue their shared objectives. Significantly, defendants work together continuously in many different venues and through many different entities to disseminate their agreed-upon deceptive public position, denying the link between smoking cigarettes and adverse health effects, denying the addictiveness of smoking cigarettes and nicotine, and denying their marketing of cigarettes to young people. The court also found that each defendant also agreed to facilitate the substantive Rico violation by concealing or suppressing information and documents which may have been detrimental to the interests of the members of the enterprise. Such information might well have been discoverable in smoking and health liability cases against defendants, and therefore could have constituted or led to evidence of the link between smoking cigarettes, addiction, and adverse health effects. And each defendant knew the goals of the enterprise, the general nature of the conspiracy, and that other members of the conspiracy would commit at least 2 racketeering acts in furtherance of the enterprise's scheme to defraud. Indeed, each defendant took substantial steps to facilitate the scheme to defraud that was the central purpose of the conspiracy, including committing numerous racketeering acts in furtherance of the enterprise's affairs. Hence, each defendant entered into the requisite conspiratorial agreement. There's really nothing else to say about the cigarette company's business practices. So now I want to give you a quick overview of the remedies that the government was seeking in this case. First, the government wanted the industry to stop using the terms light, low tar, ultralight, and mild. The government wanted the industry to disseminate statements that would correct its past deceptive statements. The government wanted the industry to disclose more of its secret documents and to maintain the document depository that was created here in Minnesota during our state litigation and a similar depository in the UK, and to disclose its disaggregated marketing data to the government. The government was seeking to enjoin the industry from any future RICO activities, which includes the dissolution of several third-party organizations that the industry had used to perpetuate deception, such as the Council for Tobacco Research. The government wanted the creation of a national smoking cessation program funded by the industry, which would include a national quit line, paid media, and cessation research. The government wanted the court to establish smoking reduction targets that would reduce youth smoking by 6% per year and would assess a fine of $3,000 for every single young person above that target. The government also asked the court to make structural changes to the defendant companies by appointing a tobacco czar that would have full access to the tobacco companies to investigate compliance with the court's order, and also appoint an independent hearing officer that could adjudicate any violations. The government also asked the court to create a public education campaign targeting youth and educating them about the dangers of tobacco and informing them of the industry's attempts to market to them. This would, of course, also be paid for by the industry. The government also asked the court to relieve the industry of its ill-gotten gains, specifically $280 billion. Again, that's billion with a B. And finally, the government asked the court to make the industry pay for this ungodly long lawsuit. I'm sure you can guess where we go next. The government did not successfully impose all of these remedies. Before the 2006 opinion was issued, disgorgement of profits was taken off the table. In the pretrial phase, the industry argued successfully to the Court of Appeals that all remedies imposed under Rico must be forward-looking in order to prevent and restrain future violations of Rico. Disgorgement, the court found, is a backward-looking remedy. The other remedies remained on the table until Judge Kessler's 2006 ruling, but she was constrained by the Court of Appeals decision to only impose those remedies that were both forward-looking and narrowly tailored to prevent Rico violations. And so, Judge Kessler ruled that she could not impose the National Smoking Cessation Program, youth smoking reduction targets, and public education and counter-marketing campaigns because the remedies were either not forward-looking or not narrowly tailored to prevent Rico violations. She also ruled that making corporate structural changes would be an unconstitutional delegation of judicial powers to non-judicial personnel. However, Judge Kessler did impose the other remedies, the prohibition on light and low tar, the imposition of corrective communications, the disclosure of documents and marketing data, the injunction on future Rico violations, and the litigation costs, which the last time I checked, which was a while ago, had topped at about $10 million. The Court of Appeals essentially upheld all of these remedies and only slightly limited some of their scope, such as not allowing the court to impose the remedies on international activities. I am now going to turn things over to Denny, and he's going to circle back and talk about the very important role that public health groups played in this litigation, and then he'll pick up the discussion of the remedies with discussion of the litigation that's been ongoing for the last couple of years. All right, thanks, Denny.
Thanks so much, Desmond, and thank you all for joining us. I really appreciate the opportunity to be part of this webinar on this truly historic piece of litigation. One of the most interesting aspects of this case is the participation of public health groups. Even though the case was brought by the Department of Justice, in 2005, 6 years after the case was filed, various public health groups were granted the right to intervene in the case. And these interveners acquired all the rights of a plaintiff. They included the American Cancer Society, the American Heart Association, the American Lung Association, Americans for Non-Smokers' Rights, the National African American Tobacco Prevention Network, and the Tobacco Free Kids Action Fund. Now, the most common way for groups or individuals who are not parties to a lawsuit to participate in the suit is to appear as amicus curiae, which is just a fancy Latin term for friend of the court. And this usually involves very limited participation. It usually involves filing a legal brief in support of one of the parties to the suit. But there is no right to participate more fully in litigating the suit. But in this case, the public health parties sought much broader participation as interveners because it became clear at the remedy stage that their interests would not adequately be protected by the Department of Justice itself. Recall that the case was filed originally during the Clinton administration. But after George W. Bush was reelected in 2004, there began to be indications of political interference by the administration in the conduct of the case. And this political interference was most dramatically illustrated on the issue of remedies. And by remedies, as was explained by Desmond, we mean the actions that defendants should be required to undertake once they were found liable for Rico violations. Now, the Department of Justice had requested, as one remedy for the industry's massive fraud, that the court order the defendants to fund a national smoking cessation program for 25 years at a cost of $130 billion. But during closing arguments in the case, in June of 2005, the Department of Justice abruptly informed the court that it was seeking only $10 billion for the industry-funded smoking cessation program over only 5 years, even though the government's own expert had testified that an effective program would require at least $130 billion. And in a subsequent filing later that month, the Department of Justice filed a proposed remedy order that confirmed the government was now seeking a sharply reduced cessation program. Well, 2 days later, the motion for permission to intervene was filed by the 6 public health groups. And Judge Kessler granted that motion less than a month later, finding that the public health groups had a protected interest in the remedies to be ordered, and that, quote, the federal government no longer adequately represents those interests, which is a really remarkable finding. Judge Kessler also wrote these words, emphasizing the unique importance of public health participation in this case. She wrote, in a case of this magnitude, it will serve the public interest for major public health organizations, such as interveners, who have long experience with smoking and health issues, to contribute their perspectives on what appropriate and legally permissible remedies may be imposed should liability be found. Well, since 2005, the interveners have been full and active participants in the case on the remedies issue. They have filed numerous legal briefs, participated repeatedly in arguments in court and in negotiations with the defendants, and have been very ably represented by outside counsel Howard Crystal and Kathy Meyer, who have done an excellent job. But the battle over remedies continues to this day. The litigation over the last several years has focused on one of the most significant remedies ordered by Judge Kessler in her 2006 final order, and that is the requirement that defendant companies make corrective statements revealing the truth about cigarettes. In her remedial order, Judge Kessler ordered the defendants to make these corrective statements about 5 topics that had been the subject of the industry fraud: the adverse health effects of smoking, the addictiveness of smoking and nicotine, the absence of any significant health benefit from smoking light or low-tar cigarettes, the manufacturer's manipulation of cigarette design to ensure optimum nicotine delivery, and the adverse health effects of secondhand smoke. And Judge Kessler ordered that these statements were to be disseminated through television, in newspapers, on corporate websites of the defendants, in pack-onserts, and at the point of sale. Well, needless to say, this was a very significant remedy, because for the first time, the companies would be forced to widely disseminate the truth about their products. Well, from the outset, the defendants have fought against these corrective statements in court. They have argued that the court exceeded its authority under Rico and that requiring corrective statements would violate the First Amendment. But in its 2009 opinion, upholding Judge Kessler's landmark 2006 ruling establishing defendants' liability under Rico, the U.S. Court of Appeals for the D.C. Circuit upheld the corrective statements remedy and rejected the company's arguments. On the remedies issue, the key provision in Rico gives the district court authority to, quote, prevent and restrain violations of Rico by issuing appropriate orders. And that phrase, prevent and restrain violations, becomes the key to understanding the legal issues that have been litigated ever since. The Court of Appeals upheld Judge Kessler's finding that the defendants were likely to continue their fraudulent conduct, and the court held that requiring defendants to communicate truthful messages about these issues to the public would make it more difficult for them to continue to disseminate false and misleading statements about these subjects. Therefore, the court determined requiring defendants to reveal the previously hidden truth about their products will, in fact, prevent and restrain them from continuing to violate Rico in the future. And the court also rejected the defendants' First Amendment challenge. The Court of Appeals held that as long as the corrective statements were confined to purely factual and uncontroversial information, they would be judged under a lenient standard of judicial review and would be a permissible restraint on the commercial speech rights of the companies. However, the court did reverse Judge Kessler on the issue of corrective statements at the point of sale. The Court of Appeals held that she had given inadequate consideration to the impact on retailers of those corrective statements, the retailers not being before the court. And so the Court of Appeals remanded the case for further proceedings on that issue. It's important to note that this Court of Appeals ruling on remedies was not a ruling on the text of specific corrective statements. The Court of Appeals sent the case back to Judge Kessler to determine the content of those statements and to resolve other issues about implementation. And 3 years later, in November 2012, Judge Kessler issued a ruling requiring specific corrective statements. That ruling, incidentally, did not include a ruling on the point of sale issue, and that remains unresolved before Judge Kessler. Well, here is one of the corrective statements originally ordered by Judge Kessler in her 2012 order. This particular one, this one of the 5, addresses the health effects of smoking. And note the structure of it. It starts with a preamble, which I have highlighted in red because the preamble has become the focus of the industry's attack. And the preamble is then followed by several bullet points with specific facts about cigarettes and smoking. The other corrective statements follow that basic structure. Well, the preamble reads, a federal court has ruled that Altria, Reynolds, Lorillard, and Philip Morris deliberately deceive the American public about the health effects of smoking and has ordered those companies to make this statement. Here is the truth. And the other corrective statements have similarly worded preambles. Well, the companies appealed Judge Kessler's 2012 order to the D.C. Circuit, arguing that she lacked authority under Rico to require these particular statements. And here the companies relied on the key ruling of the D.C. Circuit in 2005, which Desmond just highlighted, concerning whether the government could seek the remedy of disgorgement, which means requiring the defendants to disgorge the proceeds from their unlawful activities, estimated at $280 billion. In that ruling, the D.C. Circuit held in a 2-to-1 vote that disgorgement could not be sought because it was a remedy aimed at past violations and thus would not prevent or restrain future violations of Rico. This, needless to say, was a major victory for the tobacco companies, as Desmond indicated. This disgorgement ruling also was successfully used by the companies to block other remedies as well, including the funding of that smoking cessation program I talked about. Well, relying on the disgorgement decision, the companies argued that the preamble to the corrective statements also was not designed merely to prevent or restrain future Rico violations, but rather to force the companies to acknowledge their own past deceptive conduct. And in May of 2015, the D.C. Circuit agreed with the companies that its previous ruling on the disgorgement issue precluded this preamble language, which the court held exceeded the court's authority to order remedies that prevent or restrain future Rico violations. And here the court distinguished between the bullet points, which reveal the truth about cigarettes, and the preamble, which did not reveal any facts about cigarettes, but rather disclosed the defendant's prior deceptive conduct. So the Court of Appeals sent the case back to Judge Kessler again to develop new language for corrective statements. In February 2016, Judge Kessler entered an order revising the text of the corrective statements. Note that the preamble was altered. The new preamble reads, a federal court has ordered Altria, Reynolds, Lorillard, and Philip Morris to make this statement about the health effects of smoking. Here is the truth, followed by the bullet points. This preamble language was proposed by the Department of Justice and the interveners and adopted by Judge Kessler. But note, there's no reference in this preamble to the company's prior deception. Well, did this revision of the preamble satisfy the companies? Of course not. they oppose the new language and have appealed the February 2016 order to the Court of Appeals. So this is the third time the corrective statements issue has been before the D.C. Circuit. And the company's attack now focuses on the tagline, "Here is the truth." They argue that the new preamble conveys the message that a federal court has ordered companies to tell the truth about their products, which implies that they did not tell the truth in the past. So the companies maintain the new corrective statements impermissibly communicate a message about the company's past conduct and thus are not designed to prevent and restrain future violations. The companies also maintain their First Amendment challenge, arguing that the corrective statements do not convey purely factual and non-controversial information, but rather convey the message that defendants lied in the past and are being punished by being required to make these statements. But the companies do not contest the factual accuracy of the bullet points. And the companies themselves suggested alternative text stating that the statements are being made under court order. So really, the company's only objection is to the phrase, "Here is the truth." Well, how does the phrase, "Here is the truth," say anything about the defendant's past conduct? And if purely factual and uncontroversial information does not infringe the company's free speech rights, how can that information preceded by the statement, "Here is the truth," violate the First Amendment? In the final analysis, the companies object to the statement that these uncontested facts about their products are, in fact, the truth. And so, after 15 years of litigation, they still resist acknowledging the truth about their products. Well, in her February 2016 order rejecting the defendant's latest objections to the corrective statements, Judge Kessler characterized the company's latest litigation tactics as, quote, "ridiculous, a waste of time, energy, and money for all concerned, and a loss of information for the public." She went on to say that it is obvious that defendants are, once again, attempting to stall any final outcome to this long-standing litigation. Well, we can only hope that the Court of Appeals agrees and that it finally clears the way for these corrective statements to be implemented. If that happens, the many years of effort by the public health interveners will have been well worth it, and the public health will have been served. And now our next speaker, Mark Gottlieb, will discuss the impact of this case on civil litigation against the tobacco industry. Thank you.
Thank you, Danny. That was excellent. You know, in a way, U.S. v. Philip Morris is sort of the granddaddy of civil litigation against the tobacco industry. It's the big one. It was not, as many people had predicted in the 1990s when the Department of Justice was investigating the cigarette industry, a criminal case. And of course, there are criminal provisions of Rico, as Desmond had pointed out, but rather they relied on the civil provisions of Rico, making this an enormous civil case. And I'm going to discuss what the impact has been on civil tobacco litigation in the U.S. of U.S. v. Philip Morris. And before I go ahead and do that, I just wanted to make the connection that tobacco litigation, civil tobacco litigation, is a public health strategy and a tobacco control strategy and a cancer control strategy. And it's not simply an effort by victims and particularly by plaintiffs' lawyers to squeeze money out of these companies, but it has the effect of focusing public attention on the misdeeds of the industry and the harm caused by tobacco use. You know, it has created hundreds and hundreds of sort of news pegs for getting the word out to the public and to policymakers that what these companies have been doing is wrong and has caused tremendous damage. It creates cases with narratives that personalize tobacco-caused diseases and forces industry, public relations agent, and defense attorneys to characterize smokers as reckless about their own health, and that rubs people the wrong way. So it's helped to denormalize the industry and denormalize their products. And in fact, it can even provide opportunities to obtain court orders, forcing changes in certain industry practices. So that's one of the reasons why we do focus on civil litigation, on the lawsuits against Philip Morris and R.J. Reynolds and Lorillard and the like, as part of our public health mission. So there were really three different waves of tobacco litigation. I just want to provide a little bit of a background and context here. And tobacco cases around lung cancer in particular really started as soon as the concerns about smoking and health began to emerge, the quote-unquote smoking and health crisis of the 1950s. When in Reader's Digest, the Cancer by the Carton series was first published in I believe late 1952 and through 1953, and the first cases were filed in 54 involving smoking and lung cancer, and there were hundreds of them, actually, a couple of hundred cases that had been filed way back in the 1950s and 60s, and they sort of petered out by the early 1970s. And the focus of these cases was really on whether or not smoking cigarettes caused lung cancer. So the industry was defending these cases on the basis that there wasn't sufficient evidence, there wasn't scientific evidence that the plaintiff, whomever the plaintiff was, with lung cancer, or the decedent, if in the event that the plaintiff had passed away, that their case of lung cancer was caused by smoking, or any case of lung cancer was caused by smoking. And therefore, the industry didn't have any duty to warn their customers, because some of these cases focused on the industry's failure to warn customers of the risks posed by use of their products. But if there's no science, if there's a scientific controversy, or it's unproven that smoking caused lung cancer, what's there to warn about? And every single one of these cases ended up being decided in the tobacco industry's favor. And as they wore on, they became more and more expensive for plaintiffs' attorneys to bring these cases, as the defendants put seemingly unlimited resources into defending them, and actually tried to create expense for those plaintiffs' attorneys that dared to challenge them in their products in court. The second wave, so there was a lull really for about 10 years, and a second wave of tobacco litigation hit starting in the early 1980s. The key case probably in the second wave of tobacco litigation was the Chipolone case that some people have probably heard about. And there were a number of cases, I'd say probably between 50 and 75 cases filed as part of the second wave of tobacco litigation between the years 1983 and 1992. And in 1992, in the Chipolone case, which was filed in 1983, was finally resolved long after Rose Chipolone, the original plaintiff, had died as a result of lung cancer. The plaintiff's attorneys that brought that case were bankrupt. It had been to the U.S. Supreme Court, argued there twice before it was remanded for a new trial in 1992, by which time the plaintiffs and their attorneys' energy and finances had been thoroughly exhausted. And in the second wave of tobacco litigation, the industry's defense focused on, again, denying that their products caused lung cancer or any disease, but they also focused on the argument that all smokers, including the plaintiff, are all aware of the risks of smoking, but they smoked anyway because they enjoyed it, because it provided pleasure. And this was an interesting, these seem to be in conflict with one another. Our products don't cause cancer, but everybody knows, including the plaintiff, that it's dangerous to smoke, but they just did it because they enjoyed it, so they had to assume any risks from it. It was an effective strategy, and although in the Cipollone case the jury awarded $400,000 to the estate of Rose Cipollone, that was overturned on appeal, and it's estimated that the plaintiff's attorneys spent over $6 million litigating the case, and maybe more than 10 or 20 times that it's been estimated that the industry spent defending it. But one of the things that came out of the Cipollone case in the second wave was the first glimpse into some of the internal documents of the tobacco companies. So again, another wave of tobacco litigation, not a single plaintiff's victory, but more coverage in the news about this, more skepticism on the part of the public about the cigarette manufacturers and their roles. Then, as Desmond mentioned, 1994 was a very big year, and there's a whole confluence of whistleblowers, of documents, of damning testimony in front of Congress, of actions by the FDA, all really transformed the environment in the U.S., the cultural environment really around the public's relationship with the cigarette industry. And this really changed the litigation environment. Suddenly, the companies that seemed impossible to beat in 1992, that had beaten down and bankrupt plaintiffs and their attorneys, looked very vulnerable. There were a number of different types of litigation that suddenly emerged, litigation against the tobacco companies. There were these cost recovery actions where governments or third parties like insurers were trying to recover the costs of treating smokers. These included, of course, the state actions where state attorneys general were trying to recover Medicaid costs of treating sick and indigent smokers. There were class actions filed. Of all variety of class actions filed, national class actions, state class actions about addiction, class actions about cancer, and there were even secondhand smoke cases filed shortly after the release of the EPA's report on secondhand smoke that found that it was a Class A carcinogen. And of course, these secondhand smoke cases had the advantage that the victim never chose to smoke anything. And therefore might be considered less blameworthy and more sympathetic as a plaintiff. Hundreds of individual smoker cases were filed. All of these relied on the whistleblowers, on the documents, on all this damning material that was emerging beginning in 1994. A huge amount of news coverage of this also happened, and it really changed the way we looked as a society at the tobacco industry. And in fact, there were Rico cases filed before the U.S. filed its civil Rico case. There were Rico cases filed, national Rico and class actions filed in the mid-1990s. And of course, as Desmond mentioned, some of the results of this was there was a master settlement agreement and these payments in perpetuity to the states. There were some enormous individual verdicts. There was in the Boken case in Los Angeles, which was an individual lung cancer case. The jury came back with a punitive damages award of $28 billion with a B dollars. In the Williams case in Oregon, there was over $80 million in a punitive damages verdict. I think even more than that, more like $100 million in an individual light cigarette case, also in Oregon, the Schwartz case. In Florida, the flight attendants that sued as a class over their injuries from exposure to secondhand smoke settled with the industry, creating the Flight Attendant Medical Research Institute that funds and conducts research on smoking and health to this day. And an enormous Florida class action of injured smokers went to trial in 1999, resulting in a punitive damages award for the class of $150 billion. There were class actions on behalf of addicted smokers who had been injured, filed in almost half of the states. Third-party cost recovery cases were filed by the asbestos bankruptcy trusts, by countries that had to treat sick smokers around the world, such as Nicaragua, and by HMOs such as Empire Blue Cross Blue Shield. That was a lot of litigation, but you know, it wasn't all successful, many of these punitive damages awards were overturned on appeal. The $28 billion punitive damages award turned into a $28 million punitive damages award. The $150 billion punitive damages award in Florida was tossed by the Florida Supreme Court, and all of the individual class members, that class was decertified, actually, and the individual class members had to slog on in individual cases in the Florida courts, which are going on right now. And many of these claims sort of petered out. The claims by foreign countries were tossed out by courts. The trials by the asbestos bankruptcy trusts seeking money for asbestos victims who were smokers were not successful, resulted in defense verdicts. Empire Blue Cross Blue Shield also resulted in a very modest verdict that did not meet the cost of bringing the case by the HMO. And so tobacco litigation was looking for a boost, and after all of these years that the Department of Justice was building its case against the cigarette companies, it looked like perhaps that was going to come in the form of this enormous 1,600-page opinion by Judge Gladys Kessler in U.S. v. Philip Morris, finding the companies liable for violating the civil provisions of Rico, light cigarette fraud, false marketing, marketing to kids, nicotine manipulation, causing addiction. This looked like it was going to have a huge impact. And so there were three potential impacts that we looked at when this decision came down in terms of how it could affect civil litigation in the U.S. One is that it could settle claims that were addressed in the Rico case, so they wouldn't have to be relitigated every time in every court in every case. Also, we believe that the case provided a roadmap, a way for plaintiffs' attorneys to plot their cases against the cigarette companies, and a treasure map in that they could use key evidence that was brought to light in the Rico case in their own cases. So the first thing and the great hope was that perhaps collateral estoppel, which is also known as issue preclusion, could work to prevent the need for repeating the litigation over the same issue over and over and over again. It's a rather technical legal term, but the idea is basically that, look, all of the evidence was heard. The defendant had a chance to defend themselves over this issue. It has been decided. It need not be relitigated. And that would be really nice, as the Beach Boys had said in a musical way many years ago, but it really didn't turn out that way. The most likely candidate for the use of collateral estoppel would seem to have been the light cigarette fraud that is documented in tremendous detail by Judge Kessler. In a class action on behalf of light cigarette smokers that was brought in federal court in New York, in the Eastern District, Schwab v. Philip Morris, we seem to have really the perfect case for bringing it. It was brought in federal court. The U.S. v. Philip Morris was heard in federal court, so that helps. The class of light cigarette smokers alleged there were violations of Rico in that case, just as in the U.S. v. Philip Morris case. The issues were basically the same, and the judge was a very progressive and important and pretty liberal and plaintiff-friendly judge, Jack Weinstein. And it looked like he might be in a good position to open up the collateral estoppel floodgates, if you will, so that we don't have to continue to litigate the same issues over and over again. And he decided that it did not apply in that particular case. One of the reasons was Liggett was a party to the class action in his court, but was a prevailing party in the DOJ case, so there was a mismatch there in the parties. And I think this is the most important reason. Basing estoppel on a single recent victory isn't fair, isn't appropriate. And just because that the industry lost in this one case, albeit a huge case in U.S. v. Philip Morris, that shouldn't mean that every subsequent case they automatically lose, which is unfortunate. And in that particular case, because there were a number of other issues, he didn't feel that it would really serve the interests of increasing judicial efficiency. And even though he did throw out the collateral estoppel, the use of a collateral estoppel, he did suggest that in other cases it could be used, and he pointed out that in the Schwab case, the similarities between them were immense. That the defendants devised and executed a scheme to defraud consumers, that they knew that light cigarettes gave no clear health benefits, and they promoted them as less harmful than regular cigarettes, and they were successful in doing that. That the cigarette companies attempted to and suppressed important scientific research and destroyed documents. All of that could have applied, but didn't. But he suggested that maybe this should be tried again. And it was. And unfortunately, the same results in two other cases where the light cigarette findings of U.S. v. Philip Morris were sought to be used in a collateral estoppel argument, were also rejected. And one, it was the Schaefer v. R.J. Reynolds in Arizona. The other was the Grisham v. Philip Morris case in 2009 in California. In each case, for largely similar reasons to Judge Weinstein's reasoning, collateral estoppel was rejected. So although it would have been nice to not have to relitigate all of these claims, unfortunately, it is necessary. But the U.S. v. Philip Morris provides a tremendous roadmap for plaintiffs' attorneys. Judge Kessler's decision finds that the defendants falsely denied and minimized the health consequences of smoking for 40-plus years, nearly 50 years, that they've denied that they can and control the level of nicotine so they create and sustain addiction. So there's really a tremendous roadmap there for plaintiffs' attorneys to use. Again, as Judge Weinstein showed, there was, particularly around the light cigarette case, it's very powerful. Unfortunately, there aren't any light cigarette cases remaining. All of the class actions around light cigarettes have now, I think, been decided. But, you know, the marketing to youth is often something that is that is an important part of the case. The defendants caused the smoking initiation by the plaintiff. The nicotine manipulation is an important part of the case, and this is addressed in U.S. v. Philip Morris in great detail, and this has caused the addiction of the plaintiff. Suppression of information prevented the plaintiff from being able to make an informed decision, and these all go to some of the key causes of action, such as fraudulent concealment, negligence, breach of warranty, and punitive damages in civil litigation. There's a treasure map also for plaintiffs' attorneys in the Tobacco Control Legal Consortium's terrific publication, The Verdict is In, which includes citations to some of the most important evidence that is cited by Judge Kessler in her decision. So there's a lot of good stuff there. There's not the same excitement around tobacco litigation in 2016 that there was in the 1990s, but there are several thousand individual trials still pending in Florida. There's been a wave of recent filings in Massachusetts. There's some cases in the U.S. Virgin Islands and California and a few other states. And very importantly, Canada is going through right now what the U.S. was in the 1990s, in that all of the provinces of Canada are suing the industry and have lawsuits pending for medical cost recovery for their national health care system for the costs associated with smoking, and they have relied on much of the resources of U.S. v. Philip Morris. So there's a lot still there. I think I've gone a little bit over time, but let me turn this over now to Cynthia Hallett from Americans for Non-Smokers' Rights. Thank you.
Hallett, and I am not a lawyer, so what I'm going to talk to you about for the rest of the afternoon is looking at opportunities for advocacy in using the Rico findings as we move forward on these other campaigns. I think that Denny covered very well the role of the public health groups as interveners, but I just wanted to emphasize that, first of all, thank you to Campaign for Tobacco-Free Kids for inviting all of the other organizations to participate. And it was important that we were there. You know, as a membership organization, we were able to put in our declaration to the courts as we were requesting to intervene in the case that we did as an organization represent individuals that included parents of children who were concerned about the risks posed by tobacco smoke. And given that at the time the Department of Justice was perhaps weakening some of the remedies that they were being asked for, there was the interference from others, that we felt it was critical to provide a voice for those members that we represented. So again, we've seen now that the industry are racketeers. In August of 2006, the opinion came down with the thousands of pages of findings in the case, and 10 years later, August 17, 2016, unfortunately, we did not have all of the remedies in place, including the corrective statements that Denny covered earlier. I think what's also very disheartening and frustrating is that the industry, despite these findings, and despite Judge Kessler saying that not only did they engage in these behaviors for the last 5 decades, that they're likely to continue to do so, has actually come to fruition. I would say that the industry's behavior really hasn't changed very much. Perhaps in some cases they've become a little bit more careful and subtle in their behavior, but we're still seeing a lot of similar behaviors to oppose smoke-free laws, to oppose the excise tax increases, to promote electronic cigarettes to youth, and also to kind of deny or not share what they know about the health effects of the products on users and non-users. And certainly the industry is working with allied partners to create confusion and doubt around the public health benefits of the various tobacco control laws, as well as questioning about, the viability perhaps of electronic cigarettes as smoking cessation devices, while also still marketing them to youth and communities of color. But it's no surprise that doubt is one of the keys of their campaigns. We know not only from the culmination of the Department of Justice RICO case against the industry, but also previously from the Master Settlement Agreement and also from previously leaked internal tobacco industry documents, that doubt is the industry's product. This is from a 1969 smoking and health proposal from Brown and Williamson, where they say that doubt is their product because it's the best means of competing with the body of evidence or the body of facts that exist in the mind of the general public, and it's also a means of establishing controversy. We know that the industry, as a result of this case, that they suppressed its research about what it knew about the health effects of the cigarette, the health effects of exposure to secondhand smoke. It engaged in a campaign to create distractions and recruited what they called third-party endorsers, who then helped establish this controversy in the field, for instance, around the 1993 EPA report, which classified secondhand smoke as a Class A carcinogen, and it continues to deny what it knew in the past. So one of the first action alerts that Americans for Non-Smokers' Rights created and shared with its membership was this one here, which is a bit hard to see, but it is on our website. And we heard at the beginning of this call how many of the remedies were being weakened or interfered with, and so we sent this action alert to our members to remind them about the case, remind them about the findings, and it was designed to have our members contact people in Congress and the Department of Health and the Attorney General to say that they wanted to protect the integrity of not only the findings of the case, but certainly for the proposed remedies to protect public health and for their interests as individuals. We also know that the Department of Justice findings has also been used not only domestically but internationally. Certainly the World Health Organization and the Framework Convention on Tobacco Control, Article 5.3, deals with tobacco industry interference, and it calls for a transparency of government interactions with the tobacco industry, and there is disclosure of the tobacco industry activities in things including marketing expenditures and their so-called philanthropy. And the article also calls for a refusal to accept the industry's social corporate responsibility schemes, which really are nothing more than another kind of marketing and PR campaign. And then if you haven't read the book, Bad Acts by Sharon Eubanks, who was the lead litigator in the case, I recommend it. If those two binders that you saw earlier at the beginning of the conversation frightened you, the summary that's in this book, and certainly the experience that Sharon went through litigating the case, I think also casts a shadow on industry behavior, the lawyers that they use, and just the importance of the case overall for why the industry is still trying to bury the findings and prevent any of the remedies being put into place. Just to illustrate, I wanted to make sure that I'm calling them the secondhand smoke findings. I think that because in the industry documents, the industry coined the term environmental tobacco smoke, as many know, to kind of make it seem less fraudulent and the part of the cigarette, but it's in the environment. But really, secondhand smoke findings here from Kessler's decision, and I added emphasis in some of these places, the last two, where the defendants made false and misleading public statements denying that secondhand smoke, or ETS, is hazardous to non-smokers, and that the defendants continue to obscure the fact that secondhand smoke is hazardous to non-smokers, are two items that we as advocates can hang our hat on as we continue to talk to either the public, elected officials, and certainly the media as we try to continue to move forward on our smoke-free and other tobacco control policy agendas. And I think the key issue here is that, as I mentioned earlier, we continue to see very same behavior that we did prior to these findings coming out happening today with respect to our current tobacco control policies. And I think that, I personally am having a case of deja vu when we start looking at the regulation of electronic cigarettes. And believe what you will about them potentially being a smoking cessation device, but when you look at the marketing and when you look at the information that's being shared about how these are safer products and that there's no ill health effects or it's vapor mist, it really smacks of some of the arguments that were used previously with respect to tobacco cigarettes, then light cigarettes, and so on. So how have these findings from the Rico case been used for tobacco control advocacy? I've got a couple of examples, and there's certainly, it's not a comprehensive list, and I would be interested from hearing from others. But I think it's been used in a variety of ways, and I'm going to share some of them that I've heard from other partners in the field, and then certainly also that we have used here at Americans for Non-Smokers' Rights. And I think at a very basic level, this information should be used as education and training and orientation, if you will, of either new staff or for us as board members. Certainly for coalition members who are new to your coalition and just getting involved and engaged in tobacco control. We definitely want to always focus on why we work on these tobacco control policies from the health perspective. What's the public health benefit of adopting smoke-free laws or increasing the excise tax or eliminating menthol from cigarettes, et cetera. But what I find is that with coalition building, and certainly with some of our other key constituents, we need to understand kind of who the opponent is. And for us with smoke-free, it's not the smoker. It's the industry that knowingly and willingly designed a product to be highly addictive and deadly, and that they knew created secondhand smoke, which was also a carcinogen and deadly to the non-smoker. We need to make sure that people know who the opponent is and how to then be able to offer some of those arguments to educate other peers to say, the industry really isn't our friend. And in fact, this behavior is designed, again, to confuse us, make us think that they're good corporate partners, but in fact, they're just profiteers making money off of the death and disability of our people. Secondly, we have put articles in our newsletter to our membership. I found two that were examples from old newsletters here at ANR. One was in our spring 2012 issue, and we were doing an article about tobacco industry interference with smoke-free campaigns, and we were able to then remind people about the findings from the Rico case, and that if you see some of these tactics or behaviors, that they are in fact, designed and tested to be interference tactics in your communities, because we know that smoke-free laws have the intended benefit of protecting non-smokers from being exposed to secondhand smoke, but also has the side benefit of reducing, if not helping people quit, reducing the number of cigarettes that are smoked per day. And there's a quote that says, for every 3 to 5 fewer cigarettes smoked per day per smoker, the industry stands to lose billions. Being able to pick those nuggets and those quotes out from those documents or from the Rico findings, I think are very helpful to illustrate that, the industry's tactics and why they're trying to interfere with these campaigns. Also in that article, and I think that the Campaign for Tobacco-Free Kids has done a very good job as we were all trying to deal with FDA regulations and being able to execute all of their authority now, was reminding the public and elected officials and others that, this is an industry that has now been found guilty of racketeering, and they're interfering now with FDA regulations. We were also able to tell our membership and partners that the industry then was trying to pit the DOJ remedies against what were going to be FDA regulations and saying, well, we don't need to have this as a remedy because FDA will cover it over here, whether it was graphic warnings or some other labeling. And then on the FDA side, trying to counter having those warnings being implemented. And so if the industry had its way, it was going to have a null effect. We would have neither the remedies nor the FDA regulations put into full effect. And some of that has been resolved and some of it has not. and I think we need to continue talking about that. There is an element, I think, of like issue fatigue, and Mark just mentioned that, you know, there really isn't a lot of litigation right now or a lot of interest in it in the U.S., and I'm wondering if, you know, the industry is just kind of hanging out and playing the game of trying to wait out our interest or our engagement in this issue. And my hope is, certainly working collectively, that we won't let the industry kind of win by dragging this out for so long that nothing happens or that we don't talk about it. Other ways that this has been used, you can see the little graphic here. These are the, you know, 7 dwarfs who stood before Congress in the 90s saying that nicotine was not addictive. We superimpose this other statement now: can we really trust convicted racketeers who have lied before Congress to tell the truth about Prop 56? Prop 56 is California's tobacco excise tax that's on the November ballot, and the tobacco companies, Altria Group, Philip Morris, and then R.J. Reynolds have now put in about $66 million to oppose this $2 increase in the excise tax. And initially, the Yes on 56 campaign was not focusing on the industry's bad behavior. They were going to do it later, and some of the tobacco control advocates impressed upon them that it was critical to start making those messages or getting those messages out now, because we were really beginning to lose public opinion and support for the tobacco excise tax. I think that these ads have been very helpful, not just our little action alert that we've done here. But again, the public seems to be forgetting that the industry has been guilty of lying to the American public and is engaging in the same behaviors today. So I do think it's critical and incumbent upon all of us to continue to keep these messages out in the public. A last example is from our colleagues at the African American Tobacco Control Leadership Council, and you can find their information at savingblacklives.org. But they have been working very diligently on getting menthol removed from tobacco cigarettes, and they consistently are sharing with their audiences, and Carol Magruder was just sharing with me that at their last event, which was in Watts in South Central Los Angeles, talking about, again, somewhat similarly, as was mentioned at the earlier part of the webinar, that Rico case, usually it's about these gangsters. She kind of makes a Godfather reference, and then that really leaves an impression upon the audience that the industry has been found guilty of racketeering, that they cannot be trusted, and that really they are seeing, in this case, the African American and brown and black communities as a target for using their deadly product. And again, that kind of incenses the community to understand who the opposition is. It gives them an opponent to rally against, and then we have the facts about the health benefits of either, you know, removing menthol from cigarettes or quitting smoking. Again, not an exhaustive list, but I've also received feedback from the field about some of the challenges in trying to use the findings or the information from the case. And in many cases, you know, it may be from Midwestern or Southern states that are or were tobacco growing states where the industry is seen still as a major employer. Also, again, I think there is either issue fatigue or this concept that the industry's paid its dues. Maybe it's changed. We have heard that people feel uncomfortable if they cannot directly pinpoint and prove that the tobacco industry is behind a certain opposition tactic or effort, that they don't feel comfortable doing it, and that in some ways they feel like they're sort of crying wolf if they just continue to say, yeah, but they're bad guys, they're lying, they're still lying, and they're going to continue to lie. So I think the big question for us as a tobacco control community, or maybe a group think, is how do we remind the public and key stakeholders about kind of these past and ongoing, I would argue, opposition tactics in a way that we still come across as the public health leadership and experts that we are, and without kind of looking like this is the only hook to hang our hat on about why they shouldn't believe industry arguments. You know, can we identify and share other current examples that mirror kind of the past behavior? Or, you know, there are plenty of campaigns going on right now. Can we share some of those experiences and kind of compare them to activities that happened in the past under this Rico case that were deemed a violation of one of those predicate acts? that were decided at the outset of this case. Lastly, if we just think about the impact of the case broader and beyond tobacco control, I think, tobacco control as a movement has been a model for other movements, whether it's food and nutrition or now global warming. This is an article from November of 2015 looking at ExxonMobil had concealed information about what it knew about global warming and what it was doing to contribute to that, just like the tobacco industry. And no surprise that there's some of the similar bad actors, whether they're on the PR side or on the corporate leadership side. So we're seeing the impact of the case for big oil and climate change folks. And I think we're beginning to see similar activities come out for those who are, addressing and tracking big sugar now, if you will. But I do think it's our job to continue to educate the people. I think that we're now currently, while they're the interveners, and obviously the Department of Justice is working on the case through the legal system, we as advocates need to continue to work, if you will, in the court of public opinion to keep this information out there in a way that isn't offensive, that is informative, and that is illustrative of what is still happening now. And as one person shared, and it may have been something that Matt Myers had shared with folks, was that when we're looking at the tobacco industry and bringing up the Rico case, what we're really trying to address is the unethical business practices of the tobacco industry that addresses not only what they were doing then, but what they continue to do today. Just to wrap it up, I don't think that we are intentionally not talking about this as much as we can. Again, I think that we need to find a way that people are comfortable in talking about this information, but I worry that, a lot of times we as a movement, especially for smoke-free, sometimes it feels like we're a silent majority of non-smokers because we don't want to create controversy. But clearly controversy is what always wins the day, or certainly gets the attention of media or when we're testifying in front of elected officials. And so our silence, if you will, in integrating and talking about these RICO findings is somewhat a de facto win for the tobacco industry. Because again, delay, silencing, trying to prevent us from talking about this issue and sharing these findings is basically going to do them a favor and do harm to public health. If and when the corrective statements are released, and I know they will be, I shouldn't be pessimistic, that they will unfortunately not be as strong as the interveners had advocated for, and you heard Denny explain some of that earlier. And it's imperative that we all just find ways to collaborate and find these constructive ways to message the findings from this case and to share how these activities are ongoing. And again, it's not about picking on the industry. It's about dealing with unethical business practices. And again, acknowledging that this is an industry that knowingly and willingly deceived the American public about the product that it knew was deadly to users and to non-smokers. So with that, I'm going to come to an end. If you could, and I don't know, Desmond, you might want to guide folks differently, but you can use the chat box, I believe, if you wanted to add your comments or examples of how you have used the RICO findings in your advocacy efforts and or some of the challenges that you've faced in trying to do that. We can then summarize those comments and use it as a tool as we move forward to try to provide better resources for you all to implement some of these activities that we've talked about today. Thank you.
Thanks, Cynthia. And yeah, if anyone has any experiences that they want to relay, they can go ahead and put that information into the chat box, and we'll route that information on to Cynthia, and she can get in contact with you if she has more information that she'd like to get from you. I apologize that we only have a few minutes for Q&A, and I'm also going to apologize to our presenters that we may run over a minute or two. And if you have any questions right now, go ahead and start putting them into the Q&A box. We only have a couple so far, and like I said, I apologize that we won't be able to get to as many as I would have liked, but hopefully the really fantastic information that everyone presented today will make up for that. So the first question, I think I'm going to put this to you, Denny. And I'll reframe it slightly, but I think I'm going to get at what the person was asking. The question is about why some of the adverse rulings were not appealed further. And I think, correct me if I'm wrong, but the disgorgement ruling happened before the intervention. But there was at some point, I want to say 2012, 2014, a ruling by the Court of Appeals that made some modification to the language of the corrective statements, the introductory language, that was not, it was decided by a three-judge panel of the Court of Appeals, but it wasn't appealed to the full circuit or to the Supreme Court. And I'm wondering if you have any information as to why the decision was made not to appeal that decision.
Yes, I think that the 2015 decision, which struck down Judge Kessler's first iteration of the corrective statements, I don't believe that that was the subject of a petition to the full court. And one thing to keep in mind is, you know, the D.C. Circuit has changed dramatically in membership fairly recently. And there has, under the prior membership, there was a hesitation to take cases to the full membership of the D.C. Circuit because, particularly on First Amendment issues, there were some pretty bad rulings, the graphic warnings ruling in 2012 being one of them. And so, you know, that might have been part of the calculation. Now, the disgorgement ruling, I believe there was an effort to take that up to the U.S. Supreme Court. I'm not sure. And obviously it didn't go to the Supreme Court.
Great, thanks. Yeah, I would agree with you. I think probably a lot of people who aren't lawyers, or even lawyers who maybe don't follow litigation in the D.C. Circuit, wouldn't know that the makeup of that circuit changed drastically in a very short period of time, and there was significantly different decisions before and after. So when something was heard, would have a dramatic impact on the outcome. This is one I'm sort of struggling with who to put it to, but maybe I will give it to you, Cynthia, and then Mark or Denny, if you have information to add, feel free to jump in. What do you think will be the impact of the corrective statements once they're implemented? I don't think anybody really talked about it. It was maybe mentioned in past. Those corrective statements will appear in newspapers, on television, radio. There will be statements on corporate websites. I mean, it will be something that it will be nearly impossible for everyone in the country to not see, smoker or non-smoker. I would imagine it would be impactful, but I'm wondering what your take would be.
Sure, this is Cynthia. You know, I do think it's going to have an effect. I think the question is how powerful, and again, that's going to be very dependent upon what the final language is, or you know, the final agreed upon language is going to be. You know, I mean, right now we've had the same warning labels for quite some time just on cigarette packs. Clearly they'll be on the pack or in the inserts, but then it's also going to be on all sorts of media, which I think just having that more global exposure to those messages will be helpful, but you know, we'll see. I'll turn it over to the other two.
Yeah, this is Denny. I do think that the impact will be significant. I mean, one measure of that is the degree to which the companies hate this idea and are willing to fight it tooth and nail to the bitter end. Because keep in mind, you know, these are the companies being forced to tell the truth themselves. You know, this is not a Surgeon General's warning. This is the companies having to tell the truth on their own patents, on their own websites, on their own, particularly on the websites. I think that they really hate the idea of their own corporate websites having to bear these legends. Also, keep in mind, it's not simply going to be the appearance of these statements, there's going to be a lot of free media generated around the fact that the industry is having to post these statements. And so it's going to be just a massive reminder to the general public that these are in fact racketeers and that they victimized the public for decades through their massive fraud.
My one concern is that, again, because this has to be forward-looking, and I think we didn't have electronic cigarettes when this came out, you know, this only applies to tobacco cigarettes, correct?
That's true.
Right. So not smokeless, not, yeah.
It will certainly, this is Mark Gottlieb, it will certainly continue and expand on the denormalization of the industry and their products and undo tens of millions of dollars of public relations work that the companies have invested in, because it really forces them to admit that they were liars of the worst sort.
Great, thank you. I think I'm going to give you the last word on that, Mark, because we're already a few minutes over. But once again, I want to thank our presenters today. I hope this webinar was really useful for everyone who attended. It was really interesting to me and really useful as well. So thank you, everyone, for taking the time today, and enjoy the rest of your day.